Court. My name is Tom Conniff. I am here on behalf of App.No Fire. I would like to reserve those five minutes. Your Honors, as you know, this case involves a fire, a large commercial fire. App.No was a fire suppression, or I'm sorry, hood cleaning company that was hired in this case. We believe there's been multiple errors in the trial court on the summary judgment issue that would require this honorable court to reverse this matter. First of all, there are two contracts involved. There was a 2009 contract and a 2010 contract. And to give a little bit of background, Macaroni Grill, who is the owner of the Macaroni Grills around this area and nationwide, entered into a nationwide contract with Dunwell for cleaning and inspection. Not one, not the other, but both. All right? And what Dunwell does then is they go across the nation and they hire various subcontractors, such as my client, App.No. And in this case, they hired App.No to only clean the fire or the pizza oven flue. They did not hire App.No to inspect. And there is.
But there was some, I don't know if it's dispute, but if they discovered anything.
The testimony from the corporate representative from Macaroni Grill was App.No was not hired to inspect anything, but if they happen to come across something, then they should bring it to the attention of Dunwell, which they did on multiple occasions.
And I'm sorry for interrupting.
Sure, that's okay.
It's just crazy here. So if they happen to discover something, you're talking almost like an open and obvious type thing?
It would be an open and obvious situation, yeah. Something, because even Mr. McLaughlin, the corporate representative for Dunwell, the fire report in this case indicated that the potential cause of origin was the pizza flue being built too close to wood-burning members. And Mr. McLaughlin, on behalf of Dunwell, testified, recognizing that is not something that's within the scope of the duties and obligations of my client, okay? So my client was there simply to clean and not to inspect at all. In fact, it was Dunwell's responsibility to look at, all my guys had to do was go in, sweep it like a chimney sweep, then take pictures from above and pictures from below. They send it over to Dunwell. Then Dunwell decides whether or not the job was properly done or if there's any damage in there that needs to be performed. My client also did on multiple occasions bring certain items to Dunwell's attention, which they never went back and spoke to Macaroni Grill about. And that's important because my clients were not allowed to speak to Macaroni Grill. Only Dunwell could speak with them. So there's a clear distinction between who's responsible for cleaning and who's responsible for inspecting, and it was equally pled in the underlying complaint, cleaning and inspecting. And there's definitely a question of fact that the jury needs to decide in this case as to was the fire allegedly caused by App.No's improper cleaning, or was it because of Dunwell's failure to properly inspect? Now, Dunwell will make the allegation, and they have, that the cleaning and inspecting are combined together, and that's simply not the case. It's not under any of the NFPA guidelines, and Mr. McLaughlin testified specifically that's not the case. It wasn't within their scope. And the trial judge, just did not even pay any attention to that distinction whatsoever. Then going back to the contract, which is important, there's a 2009 contract and a 2010 contract. The 2009 contract specifically was for kitchen exhaust cleaning and had the indemnification provision in that contract. In 2010, Dunwell and my client App.No entered into another contract, the 2010 contract, that did not have kitchen exhaust cleaning in it, but only had fire suppression system services in it. Now, what's interesting here, and I can't imagine under any circumstances how a trial judge can make this decision, but the trial judge in this case did. He did not take into account the express testimony of my client representative, who said when App.No enters into another contract, they only have one contract between Dunwell and App.No at any given time. That's been the history behind the contractual agreement between these two parties. They never had more than one contract, and when the 2010 contract was signed, the 2009 contract was void. It was expressly testified to. The trial judge in this case stated it's not necessary to consider the testimony of the witness in this case. He deemed the testimony of my client witness as quote-unquote unpersuasive.
Well, in the contract from 2010, was there any indication in there that it superseded all prior agreements?
Yes, there's a merger clause that's in there. And the merger clause says that it does supersede all prior agreements or other understandings. Now, what Dunwell's argument is there's an exhibit to each of those contracts. One exhibit says the scope of work is, the 2009 says the scope of work is kitchen exhaust, and in 2010 it says that the scope of work is 2010. Well, that's exactly right, but that doesn't mean the 2009 contract is continuing on along with the 2010 contract. The testimony from Mr. Lamb, my corporate representative, again expressly stated, after the 2010 contract was signed, they never did the cleaning work per the contract. They did it on an ad hoc basis through another assignment system that Dunwell had on their internet system.
In regard to the witness's testimony, I thought I understood the trial court, maybe I have it wrong, but I thought I understood the trial court to say since it wasn't ambiguous, he wasn't going to consider.
Since it was not ambiguous?
Yes,
Since the contracts were not ambiguous?
that's what I understood what you
Well,
were saying. So there's no reason to consider. You seem to be saying he really made a mistake in not listening or, having the witnesses, considering your testimony is what I'm trying to say.
Right. Well, first of all, the contracts are not ambiguous. They say what they say. 2009 is for kitchen exhaust, 2010 is for fire. But you have to add context to that as to what the intent of the parties are. That doesn't speak to the necessary intent of the parties. My client specifically testified, he's the one who negotiated these contracts. He negotiated these. He said, our intent was when the 2010 contract was signed, the 2009 was void, and we took on these cleaning assignments, which covered the incident on an ad hoc basis, which means they weren't governed by the terms and conditions of the 2009 contract.
But I guess what the trial court was saying, and maybe what I'm asking you is, shouldn't you be gleaning that intent from the confines of the four corners of the document, not if it's unambiguous?
I absolutely not. I don't think you can. I mean, it's a cornerstone of our justice system that judges cannot pass upon the credibility of witnesses. And he here says, well, it's unpersuasive. This guy's saying something completely opposite, and he made a good witness. I mean, the judge wasn't there, but the jury should be able to look at my witness and decide whether or not it is true that App.No only has one contract at a time with Dunwell, and when the 2010 contract was signed, whether or not that voided the 2009 contract. That context is critical to this case, because it goes also to the inspection versus cleaning issue. And a trial judge on a summary judgment motion, I think it's not only harmful error, but it's express error that is done. That question, that issue has to go to the jury. Just because the scope of works are different does not mean the intent of the parties is ambiguous. Obviously, there's a difference between intent. And I might add, Dunwell never offered any witnesses advising what their intent was, as far as I know. So the cleaning versus inspection, which contract was enforced, there's two questions of fact right there that need to be considered before summary judgment can be handed down here. And of particular importance too, let me add this. This contract is governed by North Carolina law, all right, not Ohio law. Why is that important? Well, it's important for a number of reasons, but probably the principal reason is North Carolina is a 1% contributory state. It's still the old contributory law. So if a party is 1% contributory negligent, their claim is barred, all right? That is important in this case for a number of reasons. Number one, the indemnification, the anti-indemnification statute in North Carolina states if the indemnity is responsible in whole or in part, which covers the 1%, there's no indemnification. If the parties are in pari delicto, meaning equal fault, there's no indemnification. And in this case, the underlying complaint, which the trial judge said, well, it's App.No's or Dunwell's liability is derivative of App.No's actions, just is not true. Because the underlying complaint states that Dunwell failed for cleaning and inspection, and Dunwell, their corporate representative, specifically said that App.No was not responsible for any inspections. And matter of fact, the cause and origin of the fire, as indicated by the fire department, the potential cause was not within the scope of expertise of App.No. That was testified to by the corporate representative of Dunwell.
Yeah, I thought you said earlier, I made a note, didn't you say that the cause was the chimney was too close, you said a fire?
Yes. Yeah, the pizza flue goes up through the roof,
Right.
okay? And it's all wood members, and in the truss area, okay? And there's no access, by the way, okay?
You can't see that from.
You cannot see it from looking down and looking up. There's no access panel, you can't see it, okay? What happens is, these pizza flues become so hot, and if they're too close to the wood berray members, they ignite them. This has been scientifically shown, all right? And in this case, and in this case, by the way, the pizza flue, we know for a fact, was built too close to the truss, in violation of code, which brings in another interesting twist to this case, is Macaroni Grill, the underlying plaintiff, was responsible for the design and construction of the pizza flue, okay? So we have the underlying plaintiff who's potentially contributory negligent, we have Dunwell who's potentially contributory negligent, and then we have my client. If either one, the plaintiff or Dunwell, are contributory negligent under North Carolina law, their claims against my client must be dismissed as a matter of North Carolina law. And these are questions of fact that a jury needs to hear.
Counsel, you're in your rebuttal time. Do you want to save more time or do you
I-
want to proceed?
I would like to say my rebuttal
That's
time.
all. Thank you.
Thank you.
You have 10 minutes.
Thank you. May it please the court, I'm John Travis, representing Dunwell and Travelers Indemnity, the insurer for Dunwell. Judge Forcione basically got it right. West Bend and App.No owe defense and indemnity to Dunwell based on the facts and the law. Our only quarrel is set forth in our cross appeal. We believe a determination that West Bend owes Dunwell coverage need not await a trial. Now, this is a case that's here on summary judgment. And Mr. Connick keeps pointing to allegations in the complaint, different things. We filed for summary judgment, and it's incumbent on the other side to come forth with evidence to rebut our motion for summary judgment, which Judge Forcione obviously granted. Mr. Connick is fixating on the allegations of the complaint, but we have to look at the undisputed facts based on the affidavits, the contracts, and the depositions. 3 of them are important. First, the work done by App.No was kitchen exhaust cleaning. App.No's own Mr. Lamb, that Mr. Connick keeps referring to, admitted in his deposition that's what they were doing. And that's the subject of the 2009 contract. And of course, if you look at the underlying complaint, the plaintiffs are alleging that there's defective kitchen exhaust cleaning, and they've attached to their complaint a kitchen exhaust cleaning contract. The second undisputed fact, and important fact, is Dunwell never stepped foot at this Montrose Macaroni Grill. All of the work there was done by App.No, Dunwell's subcontractor. And the third important fact is Dunwell never did any fire protection services at the subject Macaroni Grill. Yes, there was a 2010 contract for fire protection services at other stores, never at this Macaroni Grill. Now, Mr. Connick and App.No are seizing on a phrase in the complaint about Dunwell subcontracting all or part of its responsibilities to others, but the record in this case establishes that Dunwell subcontracted all of the kitchen exhaust cleaning work at the subject Macaroni Grill to App.No. Now, again, Mr. Connick is arguing that the complaint talks about inspection. He has his interpretation of that word, but the complaint, of course, is only a starting point for deciding what the rights and obligations of the parties are and what the facts in the case are. So the complaint speaks of kitchen exhaust cleaning, has the exhibit attached to the complaint regarding that, doesn't mention inspection, but the truth of the matter is when any complaint is filed, the plaintiffs don't have all the facts. As an example, they sued App.No Pure Fire as a defendant and made allegations against it. Everyone agrees App.No Pure Fire doesn't belong in this case. It had nothing to do with anything. And the facts have determined that the only party that went to that Macaroni Grill was App.No, not Dunwell. Now, Mr. Connick likes to point to the fire report that refers to a construction defect. That goes to the cause of the fire. That doesn't concern indemnity. That doesn't concern insurance coverage. If it's a construction defect, nobody is liable. But that doesn't invalidate the indemnity undertaking, that doesn't mean the insurance company can escape its obligations to defend this case. It'd be nice if the insurance company could say, we're only going to defend cases where it's clear there's no liability, but that's not what it says. We're entitled to a defense. Now, Mr. Connick talks about the two agreements. He incorrectly states, in answer to one of your questions, Judge Schaefer, that the second agreement superseded all preceding contracts. He said that at page 3 of his motion for summary judgment, the cross motion for summary judgment. He repeated it in his appellate brief, and he said the merger and integration clause makes null and void all prior agreements. Not true. He left out the phrase relating to the subject matter hereof. That's critical. Yes, there's an integration condition, provision, but it supersedes prior agreements relating to the subject matter hereof. And the two subject matters are for kitchen exhaust cleaning and fire protection services. The second agreement did not supersede the prior agreement because they had different subject matter. Now again, Mr. Connick points to Mr. Lamb and says, well, Mr. Lamb thought this. Mr. Lamb's views have no evidentiary value. As Judge Carr, you correctly inquired, if the contract is clear on its face, you interpret the contract, the intent of the parties is evident on the face of the contract. Judge Forcione got it right.
Now, I thought this was Judge Parker.
It is.
Okay.
Oh, I'm sorry.
That's okay.
Thank you
At
for
first I
correcting.
wasn't paying attention. I heard you say that,
All
and
right,
I'm
well.
like, maybe I'm missing something.
Well.
And then I went back and looked, and I'm like, this is Judge Parker. It's
Thank
I'm
you.
just
Yes,
missing
that
it.
was the original judge. Thank you for correcting.
If I may though.
Yes.
You just said the two agreements relating to the subject matter, because there was a phrase in the 2010 one that said supersede related, except related to the subject matter hereof.
Same subject matter,
Okay,
yes.
and it covered kitchen exhaust cleaning and fire protection.
No. The 2010 only covered fire protection services.
Good.
The
But
2009 was only kitchen exhaust cleaning.
didn't you previously say that the fire protection contract did not cover this macaroni grill?
Correct. The record also shows that although it was a nationwide contract, Dunwell never did any fire protection work at this macaroni grill. They have a nationwide contract, but it doesn't mean they go to every store and they themselves or they hire subcontractors to do fire protection services. The only party that went there, and if anyone did anything wrong, it had to be App.No because Dunwell was never there. And Dunwell never did any fire protection services at this macaroni grill. Now, Mr. Connick has pointed out that App.No and Dunwell have denied liability. That's true, but it doesn't eliminate App.No's duty to indemnify Dunwell for any and all claims caused by, arising out of, resulting from, or occurring in conjunction with App.No's work. And there is such a claim by the plaintiffs, so the indemnity undertaking applies. And of course that makes sense. App.No and Dunwell agreed that if a claim arose because of App.No's work, App.No had to defend and indemnify Dunwell. There's nothing unusual or surprising about that. Now, as a fallback argument, Mr. Connick and App.No argue that the undertaking is void under North Carolina law because Dunwell's seeking indemnity for its own negligence, and App.No has pointed out to negligent hiring and training claims. Those are derivative. Dunwell can't be liable unless App.No is liable. Again, the trial judge got it right. Dunwell never went in that store, and if anyone was negligent, it was App.No. Now, on the insurance issue, the subject of our cross appeal, Mr. Connick was representing in the lower court both App.No and West Bend, and he argued that Dunwell was not an additional insured. He contended that because the pizza oven had been put to its intended use, Dunwell was not an additional insured for completed operations. West Bend has abandoned that argument. That argument was wrong. You look at the contract, and at page 6 of the brief in the Court of Appeals, West Bend says, West Bend agrees with cross appellants that the additional insured endorsement for Dunwell and the West Bend policy included coverage for ongoing operations as well as completed operations, consistent with the subcontract between Dunwell and App.No. So we got a 180 on this issue, and it's critical because the trial judge relied on the argument, which has now been abandoned, that Dunwell was not an additional insured and there were questions of fact regarding this, therefore we can't grant summary judgment on the insurance coverage issue. Well, certainly this court should not affirm the trial court's denial of Dunwell's and Traveler's motion for summary judgment based on an abandoned argument. The other basis for denial was that the fire may not have been caused by App.No's work. That's the fire department defense. It's a red herring. Sure, it may have been caused by something else, but that doesn't invalidate the indemnity obligation, doesn't say that the insurance policy doesn't apply. The fact that the defendants may win in the underlying case doesn't mean that there's no effective indemnity undertaking or no duty to defend and indemnify. A right to indemnity and coverage exists whether or not App.No's work actually caused that fire. And it may be true that App.No didn't do anything, but still you have to accept the allegations of the complaint and look at the evidence, and the evidence indicates that there's an allegation that App.No started the fire. And if Mr. Connick and West Bend want to fixate or look at the allegations of the complaint, that's fine with us. The allegations of the complaint must be construed liberally in favor of an additional insurer. We're an insurer. That's conceded now. So we're entitled to have the allegations construed in our favor, in Dunwell's favor, so we're entitled to summary judgment that we're owed coverage. Whether or not there's indemnity, we'll see what happens at the trial, but that doesn't mean we're stuck hanging out there with potential liability when we have an insurance policy and an AI endorsement that they now agree applies. So, Your Honors, if you have any questions, I'll be happy to entertain them. I believe I've addressed them.
Thank you.
Thank you very much.
You have a little over 5 minutes.
All right, thank you. May it please the court, my name is Michael Henry, and I represent the Appley West Bend Insurance Company. I'll be brief. The court, with respect to West Bend, just determined that there was a fact question on whether there was a duty to defend and indemnify Dunwell in this case. The brief discusses the arguments. There is an additional insured endorsement, and Dunwell would be an additional insured in certain respects, but under the policy only if their liability arises out of App.No's negligence. And there is questions of fact on that. There's evidence that App.No was only retained to clean and take photographs, which they did in a correct manner. There's no evidence otherwise. And therefore, you know, the evidence looks like App.No did nothing wrong. On the other hand, there are allegations specifically against Dunwell for their own independent negligence. And that's why the court decided that there's fact issues on whether there's indemnity. As for the duty to defend, the old rule used to be just look at the four corners of the complaint. And if you look just at the four corners of the complaint, there are allegations that Dunwell is liable solely for the negligence of App.No. But since that line of cases came out, there's been cases qualifying that, saying if the allegations are frivolous or groundless, that there may be no duty to defend. And then here it's going to be the allegation, or is the allegation of App.No and West Bend, that the allegations against App.No are frivolous and groundless, and that the only liability for Dunwell arises out of their own acts.
Well, and I understand that, but I guess the trial court didn't say, well, the allegations are frivolous or groundless, that there was an issue of fact.
There's an issue of fact as to whether there is coverage,
Right.
duty to defend, and indemnity.
I guess my concern with that is, then couldn't you always just say that and you would never have a duty to defend?
Well, in the long run, the court may decide we do have a duty to defend, and then
But
Or-
how far does that go before that may happen?
I suppose you do it at your own risk, and in the
I was
long run,
gonna
you're going to be
say.
paying for the indemnity and
Maybe
the
bad
defense
faith.
and everything else. Well, I guess that's a possibility down the road. Of course, Dunwell does have a defense through their own insurance company that has a duty to defend also, so they're not just left hanging.
Okay.
And maybe that's a fact that insurers take into consideration. If they're leaving some poor person with no defense, maybe they'll be a little more willing, even if they feel that allegations are groundless or frivolous to jump in, but that's not the case we have here. Here, they do have insurance, they do have a defense, and West Bend took the actions they did, and in the long run, if it's determined that they had a co-duty to defend or a primary duty to defend, I'm sure they'll be paying back travelers for that. But that's the question of fact that the court's dealing with, and we're dealing with now. And West Bend feels that the court decided those issues correctly, and there's fact issues with respect to the duty to defend and indemnify Dunwell in this case. If there's no more questions, I really didn't.
Okay, that's fine. Thank you so much for all of you. Oh, I'm sorry. You still have. Well, I was just gonna.
Don't ignore me, Your Honor.
I was just, listen, I was just going to apologize for all the confusion, and I just add more to it.
That's
so
okay.
I apologize.
Hopefully I'll be brief, but I do want to address Mr. Travis's, couple of comments by Mr. Travis. There is absolutely an issue of whether or not Dunwell is separately negligent in this case over and above anything App.No might have done that Dunwell would be derivatively liable for. First of all, App.No was required to follow very specific protocols, guidelines, and procedures that were drafted by Dunwell, provided by Dunwell, and represented by Dunwell to Matt Grill that would be followed. App.No followed those protocols, guidelines, and standards to a T. The Dunwell corporate representative, Mr. McLaughlin, testified at deposition that App.No followed all their guidelines and did not do anything wrong. So, if App.No is found liable because they did the wrong procedures, then that's Dunwell's, and that's on a national contract. And I go back to the national contract because it can't be understated, because that's what governed all these nationwide restaurants, and App.No was only at the one in Akron. So if App.No did everything right, like Mr. McLaughlin testified they did, and yet it's found that App.No, by following Dunwell's guidelines, was negligent, well then Dunwell's negligent, not App.No, because App.No was required to follow those guidelines. That's number one. Number two, yes, App.No was hired to do kitchen exhaust cleaning. We don't dispute that. We've always said that. They weren't hired to do anything else. Now, Mr. Travis also said, it's critical that Dunwell never stepped foot in the Macaroni Grill. I agree that is critical, because they were responsible for inspecting these stores. Inspection of a pizza flue system or an otherwise fire suppression system in a restaurant is far more advanced and far more involved than taking a chimney and sweeping out the flue and taking pictures from above and below. So yeah, we agree, Dunwell was never in a store. That was negligent. And that's what the underlying complaint is alleging as well. And I also might add, Dunwell was responsible for reviewing the photographs from my client, and my client would never get paid. They can't get paid unless they do the work appropriately that is documented by these photographs. Dunwell always paid App.No, without an exception. And then the next thing Mr. Travis indicated is Dunwell did not do fire protection services. Well, that's what they contracted them for. Mr. McLaughlin testified, we only hired App.No to do inspection services. So, okay. Also, again, App.No, there's no negligence in this case that App.No performed any negligence or performed any actions negligently. And that is married to the indemnification provision in the contract, and that's what I'm here to talk to you about. I'm not here to talk about the additional insured aspect. In the contract, the contractual indemnity, if App.No didn't do anything negligent, and this is critical, and if Dunwell was 1% negligence, okay, let's take, for example, their guidelines, and Dunwell's guidelines, protocols, and procedures were somehow defective in accordance with NFPA guidelines, et cetera, and App.No followed those guidelines, then Dunwell is at least 1% negligent, and there's no claim that they can assert against my client for indemnification or anything else at that point under North Carolina law. So the questions of fact are in fact married to the indemnification issues in this case, and there are so many questions of fact abounding. There's so many questions of fact that Judge Parker unfortunately decided to rule upon himself that it was prejudicial error, it was harmful error, and this should be left to a jury to decide these questions. Not a single judge who says he can just read the contract and decide from the contract that there's no questions of fact, because in this case, that's just not the fact, because there's too many facts regarding the intent that are compounding and coloring the issues in this case.
And your time is up.
Okay. So I would ask, on behalf of the App.No, Your Honors, that you please reverse and remand the decision that Judge Parker rendered in this matter. It's been a privilege being here again. Thank you.
Thank you very much. Thank you, all of you, for your presentations to the court, and the court will take the matter under advisement and will issue a written opinion that will be sent to all the parties on appeal, as well as you can look on our website for this court and Supreme Court website.
Thank you.
And I do